actually, when they did a scan, but she was okay.
Good afternoon and welcome to the September the 22nd convening of the Baltimore City Board of Municipal and Zoning Appeals. Before we get underway, we have some house rules first we'd like to go through. You'll note that there are a number of microphones which are arrayed around us up here, and those microphones are all very sensitive. They're not only for the purpose of amplification, but they're also for the purpose of recording. And conversations in the galleries, cell phones, pagers, and the like going off, anything that plays any sort of audible electronic noise disturbs that process. Additionally, you'll note that there are 2 video cameras which are mounted on the wall behind us up here, and there are 3 video cameras mounted on the wall behind most of the gallery. And these proceedings are also being recorded for broadcast on the city's cable access network, and cell phones, pagers, and the like going off, conversations being conducted, not just are generally disruptive, but they also interfere with the videotaping of these proceedings as well. So to the extent that you have a cell phone, a pager, anything that makes any sort of audible noise, anything that plays a ringtone and the like, please at a minimum set that to a vibrate only position, if not off. And similarly, if you need to have a conversation, we ask that you please take that out the double doors to your rear. We will be voting at the end of the day, and you're certainly more than welcome to hang around and enjoy a civics lesson. But if you have other plans for your afternoon, we certainly can understand that. And you can simply call into the zoning board office in the morning and find out how we ruled. If you take out pen and paper, I can give you the number for the zoning board office, and I'll read this off a couple of times so you have a little bit of time to get your pen out. The number for the zoning board office is 410-396-4301. Again, that's 410-396-4301. You will, however, need to wait until you receive the formal written outcome of your case. That should be forthcoming in about 3 to 4 weeks before you'll be able to get your permits. And we certainly ask that you first get proper permits before conducting any work in Baltimore City. The procedure for the cases today, if you're the appellant, you will come forward and stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone is up here, we'll get you sworn in, and we'll first start with the appellant. After that, we'll be given the opportunity to let the board know what it is that they're proposing, go over any issues that may be involved, present any witnesses or other evidence that they would like to offer in support of their case, and respond to any questions that the board may have. Once the appellant has concluded with their presentation, we'll then turn to the opposition, who'll be given the opportunity to present their side of things. Once they're concluded, we'll go back to the appellant to respond to any points brought up by their opposition, if any, and to give a closing statement. We won't be going back and forth, unnecessarily delaying things. If you are here in opposition to any case, we ask that you please sign in on our signing sheet, which is being held up there by Mr. French. The signing sheet allows us to know not only generally which cases have opposition, but also allows us to know who needs to receive those written notices I referred to earlier. Similarly, if your case is postponed, we need to know how to contact you to let you know when that case is going forward. So if you're here in opposition to any case, please sign in on the signing sheet. We'll be generally going in the order in which the cases appear on our docket once we dispense with some preliminary issues. And first are the cases on, well, we have a couple of postponements actually. First, 2015-301, 1501 South Highland Avenue, and 1516 Bayless Street. That case has been postponed. And 2015-305, 24 East Madison Street, that case is postponed as well. So if you're here in reference to either of those two cases, they will not be going forward today. And so long as you're signed in on a signing sheet, we'll let you know when they will be going forward, but they will not be going forward today. Next are the cases which are on our consent agenda. The cases on our consent agenda consist of cases where the zoning board staff has already reviewed these files and the board has determined that, that we have sufficient information in the record to approve these appeals. We're going to call all the consent cases together as a group, and once everyone's up here, we'll get you all sworn in, and we'll then give you the opportunity to add any additional information which you would like to have added to the record in any of those cases, and we'll call each in turn once everyone is up here and sworn. So the first case on our consent agenda is 2015-235, 1829 Gough Street, John Cole. Next case is 2015-282, 411 North Charles Street, Caroline Hecker. After that, 2015-299, 2633 Fate Avenue, MLMLG Co. LLC, care of Matt Nofel. And also is 2015-300, 126 East Giddings Street, which is also MLMLG Co. LLC, care of Matt Nofel. After that, we have 2015-308, 3432 and 3436 through 44 Frederick Avenue, 3441 Old Frederick Road, and known as Southside Old Frederick Road, 212 to 214 feet west of, well, I guess, and 4 feet west of South McCurley Street. That's Hunt Real Estate Services, Inc., care of Mark Hager. After that will be 2015-309, 614 South Chapel Street, Anastasia Sherbach and Jeremy Steinberg. And then 2015-315, 1604 East Clement Street, Butch Bartlett. 2015-316, 1308 West Lombard Street, Abdul Aziz Husseini. 2015-318, 1441 Woodall Street, Nils Schroeder. And last, 2015-319, 2504 Druid Hill Avenue, Marin Bear.
Officially off.
So everyone, if you can all raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
All right, first case, 2015-235, 1829 Gough Street, John Cole. Mr. Prettle.
Afternoon.
Afternoon. We have this as an application to construct a 3-story rear addition with first, second, and third floor rear decks and rooftop deck. Is that correct?
That's correct.
All right. Mr. French, anything for the planning department?
Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
All right. And Mr. Prettle, was there anything further you would like to have added to the record at this time?
No.
All right. Zoning board staff, having previously reviewed your application, will determine that there is sufficient information to approve your appeal.
Thank you.
And did you have another one? Oh, that's right. That's not consent. All right. Next, 2015-282. Thank you, Mr. Williams. 411 North Charles Street, Caroline Hecker.
Good afternoon, Justin Williams, Elizabeth Martin Greenberg LLP, with my partner Caroline Hecker and Oren Orbach from 411 North Charles Street, LLC, the applicant.
Afternoon, all. And Mr. Williams, we have this as an application to house 9 dwelling units with lower-level commercial uses at the premises. Is that correct?
Correct.
All right. And Mr. French for the planning department.
Planning Department has reviewed this application and recommends approval of the appeal. Thank you.
Thank you. And Mr. Williams, was there anything further you would like to have added to the record at this
In
time?
the packet of materials I gave to you, there's a letter from the Downtown Partnership. There's also a copy I gave to Mr. Tanner.
Okay. Did we have that already?
Yes, we do.
Okay. Is that it?
That's all.
Okay. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thanks, good luck. Next, 2015-299, 2633 Fate Avenue, MLG Co., LLC, care of Matt Nofel.
Good afternoon.
Afternoon, sir. We have this as an application to construct a two-story rear addition and rooftop deck at the premises. Is that correct?
Yes, sir.
All right. Mr. French, anything for the planning department?
The planning department has no comment on this application. Thank you.
Okay. And Mr. Nofel, was there anything further you would like to have added to the record?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we determined there is sufficient information to approve your appeal. And next, 2015-300, 126 East Giddings Street, MLG Co., LLC, care of Matt Nofel. And this also is an application to construct a two-story rear addition and rooftop deck at these premises. Is that correct?
Yes, sir.
Mr. French, is there anything with regard to this property from the planning department?
Planning department has no comment on this application. Thank you.
Thank you. And Mr. Nofel, was there anything further you would like to have added to the record at this time?
No, sir.
All right. Zoning board staff, having reviewed your application, we've determined that there is sufficient information to approve your appeal.
Thank you. Have a good afternoon.
Take care. Next, 2015-308, 3432 and 3436 through 44 Frederick Avenue, 3441 Old Frederick Road, and known as South Side Old Frederick Road, 212
212
to
feet, 4 inches.
4 inches, thank you, west of South McCurley Street. Hunt Real Estate Services, Inc., care of Matt Hager. Afternoon. You can, both of you gentlemen, identify yourselves, please?
Sure. I'm Mike McManamy from Hunt Real Estate Services.
Afternoon, sir.
I am Eduardo Intriago with Macer Consulting.
Okay, sir, if you can spell your last name for our reporter.
INTRIAGO.
Okay, and sir, if you can also spell your last name.
Sure. McManamy.
Okay, got that. All right. No?
All I got is Intragio. What's the rest of the name? Thank you.
And so, okay, yeah, your card would be easiest.
Yeah, it's
Perfect.
a lot of consonants in there.
All right, gentlemen, we have this, an application to install double-faced freestanding ID sign in the residential portion of the lot, to construct lots into one lot, construct a one-story variety store in the B3-2 portion, but with driveway and ID sign located in the R5 residential district. Is that correct?
Yes, sir.
Yes, sir.
And Mr. French, anything from the planning department?
Department of Planning has reviewed this application and the designs and has no objection to the appeal. Thank you.
Thank you. And gentlemen, was there anything further you would like to have added to the record at this time?
No, sir.
Okay. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thanks, good luck.
Thank you very much.
Next, 2015-309, 614 South Chapel Street, Anastasia Sherbach and Jeremy Steinberg.
Anastasia Sherbach, good afternoon.
Afternoon, Ms. Sherbach. We have this as an application to construct a second-floor rear addition at the premises. Is that correct?
That's correct.
All right. Mr. French, anything for the planning department?
Planning department has no comment on this application. Thank you.
Thank you. And Ms. Sherbach, was there anything further you would like to have added to the record at this time?
If necessary, I have a letter of support from a neighbor directly adjacent to the property.
Okay.
Other neighbors have been notified but didn't express any objections.
Is that it?
Yes.
Okay. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal.
Thank you.
Thanks, good luck. Next, 2015-315, 1604 East Clement Street, Butch Bartlett.
You don't.
Afternoon, sir. We have this as an application to construct a two-story rear addition with second-floor rear and rooftop decks. Is that correct?
Yes, sir.
Mr. French, anything for the planning department?
Planning department has no comment on this application. Thank you.
Thank you. And Mr. Bartlett, anything you would like to have added to the record this time? No? All right. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal.
All right, thank you.
Thanks. Take care. Good luck. Next, 2015-316, 1308 West Lombard Street, Abdul Aziz Husseini.
Sir.
Mr. Husseini, we have this as an application to construct a one-story rear addition at the location. Is that correct?
Yes, sir.
Okay. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
All right. And Mr. Husseini, was there anything further you would like to have added to the record? Nope. All right. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal. Thanks. Good luck. Next, 2015-318, 1441 Woodall Street, Nils Schroeder.
Yes.
Afternoon, sir. We have this as an application to construct a two-story rear addition with second floor, rear, and rooftop decks. Is that correct?
Yes, sir.
All right. Mr. French, was there anything for the planning department?
Thank you. Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Schroeder, was there anything further you'd like to add to some of the record?
I have letters of approval from my civic association and my two next-door neighbors.
Thank you very much for those. Anything else? Nope. All right. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal.
Thank you.
Thank you. Take care. Last, 2015-319, 2504 Druid Hill Avenue, Marin Bear.
Hi.
Afternoon. Ms. Bear, we have this as an application to house two dwelling units at the premises. Is that
Yes.
correct? All right. Mr. French, anything for the planning?
Thank you. Planning Department reviewed this application and has no objection to the appeal. Thank you.
Thank you. And Ms. Bear, was there anything further you'd like to have added to the record?
Just that when I purchased the property, I mistakenly thought it was zoned for 2 units. Apparently, it had previously been zoned and that had expired, so I'm just trying to pick up where the previous person left off.
Gotcha. Thank you very much.
Thank you.
Is that it?
Yes.
All right. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal. Thanks. Good luck. All right. Next, we're going to address the remainder of the cases on our docket. And those cases will include cases for which opposition is signed in. Frequently, we found that opposition is the result of either a lack of communication or miscommunication between the parties. And it can be useful to offer the parties an opportunity to have a discussion to see if they can resolve whatever issues they have between themselves. Obviously, if two opposing parties on an issue approach the board and ask the board to resolve the dispute, one of those two parties is bound to go away disappointed. And this is your opportunity to avoid that unhappy fate. So I'm going to call off the cases where there's opposition that has signed in, and I'll ask you to stand at that time. And while you're certainly don't have to take the opportunity to speak with one another, we do appreciate and encourage it.
I'm an interpreter for Mr. Gallagher. I just wanted to let you know that I'm here. Sign language interpreter.
Thank you.
Okay,
That's
Mr.
Mr.
Gallagher. Yes, thank you. All right. First case where opposition is signed in is 2015-289, 530 South Decker Avenue, Charm City Design and Development, care of Tony Valeri. Okay, and have you folks had any discussions?
We've discussed what their plans were, and I'm opposing to those plans.
Okay, any prospect of a resolution?
Yeah, I'd be open to it.
Okay. Doesn't hurt to talk. Just step outside and let us know if you reach a resolution, and if so, we can get you called up and we'll put it on the record. All right, and the other case where opposition is signed in is 2015-311, 3721 Roland Avenue, Michael Gallagher. And have the parties had an opportunity to have a discussion in this case? Sure.
Yes.
Okay. And any prospect of a resolution?
There has been no discussion today, just previous emails, but it doesn't seem like they want to talk. So,
We've had discussion.
Okay, have a seat.
thank you.
All right. Yeah, that's right. This one. And also 2015-322, 5120 Harford Road, Tamika Williams. Okay, and who signed in on that case? You, ma'am? And have you folks had any discussion?
No, it's, my concerns are just simple, but serious in nature.
I've never met her.
Okay, well, that's why I asked. So, and she said that there hadn't been discussions, so if there had been, but you'd never met her, that would be sort of odd. But would you folks like to step outside and introduce yourselves and see if you can get something worked out? Doesn't hurt to talk. You're also at the end of the docket, so there's.
Yeah, I know. I think it's just, it's very simple. I don't have an objection to a daycare center. My concern's from a safety standpoint that there's absolutely no stopping there between 7 and 9 in the morning. And I catch the bus there, and when cars stop, and it's Harford Road, and they're flying, and all of a sudden there's a parked car, it's just, I don't know how women are gonna unload children, and I just don't see how that can happen safely.
Well, maybe you two can have a talk, and maybe the applicant has some ideas on that, and.
Well, there's absolutely no way that a car can stop someplace where it says no stopping 7 to 9.
Okay, well, this is just, folks, we're not hearing the case now. So you can step outside and you can talk about what your concerns are, and you can see if you can answer them, and then.
Tell her my concerns, and then.
Okay, we can do that.
Yeah, great. All right, first case, 2015-238, 3242 Foster Avenue, Pig and Rooster Smokehouse.
Move this back just.
Sure, sure, you can even move it to the side if you need to.
Appreciate that.
Sure. All right. I'm presuming your counsel, sir?
Abraham Hurdle for the Pig and Rooster, and my client is here with me.
Natalie DiFrancesco.
Okay. And we have this as an application to add live entertainment to the existing tavern with kitchen and outdoor table service. Is that correct?
That is correct.
All right. And ma'am, you are?
Elizabeth Copeland.
Okay. And are you here in support of it? Are you in opposition?
I'm here in support of it. I'm a member of the Canton Community Association.
Okay, if you want to get on that side. Okay, and if all those intending to give testimony can raise their hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
All right. And do we have staff reports, please?
We have one report from planning.
Thank you. Planning Department reviewed this application, noted this property is located in an R8 zoning district, and as a tavern is a nonconforming use in an R8 zoning district. It would be classified as a Class 3 nonconforming use, and there is a provision in the zoning code, Section 13-405B, which states that in no event may a Class 3 nonconforming use in a residence or office residence district be changed to any use in connection with which live entertainment or dancing is provided. The department therefore believes the board is not authorized to approve this application. The department therefore recommends disapproval of this appeal because the zoning code does not authorize nonconforming uses in residential zoning districts, such as the R8 district containing this property, to be changed to include live entertainment or dancing. Thank you.
Okay. Counsel.
Thank you. With me, I have a letter from the Canton Community Association
Okay.
with their support, and I have a petition with, it appears to be over 50 neighbors in the immediate vicinity. In addition, my client lives in the immediate vicinity. I'll go into some questions in a moment. Yeah.
Well, is this I guess the nature of the objection posed by the planning department is that this is a non-conforming use, a Class 3 non-conforming use, and that the code says that that the board can't grant a appeal which seeks live entertainment with a Class 3 non-conforming use in a residential district. So I guess the first hurdle to get over is how do we deal with that?
I think the board can do whatever they'd like. I think that planning may have an objection here, but I think the situation is, in this case, given the significant and overwhelming support from the community, it isn't a situation where if there is a decision by this board to approve it, that there's going to be any problems in the future. This sorry, I'm used to being liquor board, I apologize. This business owner in business is part of a pair. They have a different place across the street, or I think a block away. And it's simply a situation where they're trying to get live entertainment to keep people in the area, keep people safe when they drive to Fells Point to see live entertainment. And I think live entertainment, might even be a strong term for what they're seeking to do. Live entertainment, you kind of think loud music, fireworks, Kiss playing with a 10-piece band. This isn't going to be the situation there. I'm not even sure there's going to be any amplified music at all. They have their plans, just to kind of go forward a little bit on that, is to have trivia, which I'm not even sure if it qualifies as live entertainment. To have, two-piece bands, which I'm not even sure two-piece is the way I would describe it. Maybe two guys with a guitar, and these are going to be two acoustic guitars, no amplified music. There's going to be no dancing. All the windows will be closed. The neighbors are, they are the neighbors. They are active members in the community. There have been other establishments in the area that have had problems with live entertainment recently. And this is a group that was active with the community to seek change with those other kind of troublesome issues. So these aren't necessarily owners or operators who live outside the city, are not going to be sensitive to the area. In fact, my client lives within, it's a block and a half?
It's pretty much diagonal from the establishment. It's literally on the same block. It's on Foster, but I live on Clinton, and it looks at the bar that way.
And as you can see from the letters of support, they went around to all of the individual neighbors after passing out a letter with the individual neighbors in the area seeking support. And there's nobody here in opposition except Mr. French, who I do very much respect his opinion on. But there's no neighbors, there's no one voicing concerns that this is going to be a problem in the area. Canton Community Association, as you're well aware, is probably one of the more strict and yet also reasonable community groups in the area. If they had concerns, they would be here, or this just wouldn't even have come this far. This isn't a situation, again, where, this is iffy for the neighborhood. They've been operating in the area. This establishment, I think, over a year. In the other establishment, over 2 years. So they're kind of well entrenched in the area. And the goal here is just to kind of stay afloat. They think that having, small, and again, I think live entertainment is a strong term for it, but to have a musical presentation, let's say, would help keep people in the area on Fridays and Saturdays, and they're not looking to be open till 2 a.m. I think it's certainly approvable by the board. I don't think there's any reason that, I'm not sure who would appeal the decision at this point if the board did it, which is always how I look at cases, is am I going to get overturned? And I don't think the board
I guess
would.
the concern I have is, I hear what you're saying.
Sure, please.
But I'm not sure we have, as the chairman said, I'm not sure we have the authority. So I'd like you to address 13405B2, if you would.
Which says that it's a Class 3 nonconforming use in a residence or office
Says in
residence.
no event may a Class 3 nonconforming use in a residential or office residential district be changed to any use in connection with live entertainment or dancing.
Well, it's my understanding from speaking with my client that the previous establishment may have had live entertainment. I did check the record with the board, and it doesn't indicate that the use may have been on there, but they may have had some form of live entertainment. And my understanding is the record keeping with regards to live entertainment has changed a bit. Again, I think the board absolutely has the ability to approve this. I think the question is if someone's going to try to appeal or overturn that decision. I don't think there's going to be a situation in that regard. And I think that since this operation, because it's a non-conforming use in a residence, this use pre-existed this rule, 13405B. 13405B is not from 1971. It is not the cause of the non-conforming use. It is a recent rule, and this BD7 tavern use has been in place for decades. It pre-exists this rule, which I think allows the board, in this case, to grandfather in the decision to permit live entertainment at this location.
So let's sort of unpack what it is you're proposing. because you went through some suggestions as far as what your client has in mind, as far as what would or might be live entertainment. So the code says live entertainment means any one or more of the following performed live by one or more persons, whether or not done for compensation, and whether or not admission is charged. So one is a musical act, including karaoke. I think that might cover the two-man band that you were talking about.
Possibly.
Theatrical act, including stand-up comedy. That's kind of interesting because you were talking about karaoke, not karaoke, you were talking about trivia, which
I take my trivia very serious. It's not a comedy act, not for me.
Certainly not, but the idea there is that both, I guess the parallel there is that that there's talking. There's someone who's leading the process, calling out,
He arguably has a microphone, too.
Yeah, I'm sorry?
He arguably would have a microphone, too.
That's correct. So, though I will submit that that explicitly trivia is not listed as one of these. But then it goes on and says play, review, dance, magic act, which also involves sort of a central person. They're doing magical tricks, but a lot of times they're also engaging the audience in conversation. A disc jockey or similar activity. And then there's an exclusion for adult entertainment, which is dealt with in a different side. So I can see where the trivia is, like I said, I think that that's murky. The band, though, the two-person musical act, while not Kiss and a 10-piece band, I think still does fall into that live entertainment issue. And I guess if I'm hearing you correctly, you're saying that that there's some evidence that the use predates the provision in the code prohibiting that, and you're looking to simply continue that use.
Correct.
And how long has your client been in the location?
My client has been there for a year, is my understanding about, I think, is the situation. I can go through these questions with her if you like. I think it might be even better, because she's actually went to the community meetings and done all
I
the
was
work.
actually going to suggest, why don't we hear some testimony?
Excellent. Natalie, you live in the area, is that correct?
Yes.
And you've gone to the Canton Community Association asking for approval in this matter?
Yes.
And what has their kind of overall opinion been of this?
Overall, they're in support of us obtaining assuming that we get approval from you. They're in support of us. I think he passed you the letter from the Canton Community Association stating the guidelines that we mostly already adhere to anyway. We're very respectful of the neighborhood. I myself, as a neighbor, am very big on respecting the community. My neighbors are angry. They know where I live. I don't want to make anybody mad, that's for sure. We definitely think this would be, an asset to more of towards the Brewers Hill side of Canton to kind of keep everybody a little bit more in our area where our smaller, newer bars are, keep people from going all the way down to Fells Point or all the way over to Federal Hill. It's kind of why we're looking to add this. I've been in my house for, I believe, 4 years now. We've owned Pig and Rooster for just over a year and a half almost, and then Chaucer, which is one block up, we've had for about 2.5 years.
And you indicated to me that one of the reasons you were looking to do this is because your restaurants or businesses are called upon to do fundraisers on occasion.
Yeah, we're very active in the community. We're trying to do, on average, a minimum of 2 fundraising efforts a month per location. We just did one for a big block party for the Cystic Fibrosis Foundation. We do a lot for the St. Francis Neighborhood Association. We're very big on giving back. It's kind of our way to thank the community for coming in and supporting us. We like to give it back and support them.
To your knowledge, as of today, you haven't heard any people in opposition or in disagreement with this proposal?
No.
And you went around door to door to get signatures, is that correct?
Yeah.
And you said you talked to over 50 people?
Of those that were available, yes.
Now, your building directly abuts a residence, correct?
Yes, and he is on that list, as well as, I believe it's the immediate surrounding residential homes have all signed that.
So the neighbor with the most direct kind of
Yes.
disadvantage
I
from
believe he's
this.
actually on the first page for signatures.
And if you were granted live entertainment at this establishment, you wouldn't have any amplified music, is that correct?
No, it wouldn't play any louder than the existing sound system that we already have. It would be acoustic, probably at the very most 3 people, but most likely about 2 people. We're thinking acoustic guitar and maybe someone singing, but nothing louder than the music we already play.
And maybe trivia night, something like that? You keep the windows and doors closed during entertainment times? And if you had any concerns in the neighborhood, you would address those immediately?
Oh, absolutely, yes.
If it was a requirement of this board to have a probationary period, would you agree to something like that?
Yes.
And in the over 2 years that you have been at the various establishments that you own, you guys haven't had any zoning violations, correct?
No, not.
Any noise violations? Any health code violations?
No. Oh, no, sorry.
And no liquor violations, is that correct?
No.
In this neighborhood, the Canton Community Association, they do monitor this area very closely, correct?
Yes.
And there was recently violations in the area,
Yes.
but they weren't with your establishment at all, correct? I have no further questions for Natalie.
Okay, and I guess the one question I had, Ms. DeFrancesco, is your council had raised the possible point that there had been prior, I guess that the prior owner may have had live entertainment at, I guess, the same location. And what do you know about that?
She told me that they did at some point have live entertainment, but she couldn't quite recall when or if it had expired, but they did at some point there when it was, the previous business was Hummer's Bar and Grill. They did at some point have live entertainment.
Okay. All right.
I have nothing further to add. If there's any other questions, we'd be happy to address them at this time.
No? Anything you wanted to offer me?
Well,
Sure. Miss Elizabeth?
Yes, Elizabeth Copeland for the record. I am the past chairman of the Baltimore City Liquor Board and a 7-year member of the Liquor Board, so I'm well-versed in balancing the law as it's written, as well as the interests and the requests of neighborhood associations and businesses. And in my past position, reading the live entertainment law and taking a look at that to look at it from the legislative intent, and at our time, our interpretation was that it was to cease the proliferation of mega bars and to give some respite to neighbors who were oftentimes impacted by business owners who were absent or didn't care, to be quite candid. And in this instance, we don't have that. We have a neighborhood association. I'm a member of it, the Canton Community Association. I sat literally in those chairs. So I'm very familiar with the arguments that's presented, and I believe that Natalie is a good business owner. I think that there is an opportunity for this board to write a record that the past practice of Hummers provides an opportunity for live entertainment to be granted as a grandfathered clause. And I will end on that if you have any questions or concerns. Thank you for your time, and I hope you approve this.
Questions or concerns? Thank you.
Question.
Yes, sir.
Does your client know how long the previous owner owned Hummers, is it called?
She had Hummers, I believe, for 8 years. She was there for 8 years before we took over.
And you acquired it a year ago? You said?
Just about a year. It was just over a year ago. In April, we took over management, and then we slowly transitioned to the taking of the liquor license.
Thank you.
All right. Thank you.
Thank you.
Have a good day. Thank you again.
Okay. Next, 2015-252, 2 West 21st Street, Friday Noir LLC, care of Katrina Friday.
Are they outside?
No. Okay. Skip that. 2015, yes, 2015-289, 530 South Decker Avenue, Charm City Design and Development, care of Tony Valeri. Afternoon. And Mr. Prettle, we've got this as a application to construct a second floor overhanging rear addition and rooftop deck. Is that correct?
That's correct, and we've actually come to an agreement out in the hall. I guess once they get sworn in, I'll have a chance to go over what that is.
Okay. All right. If you can both raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. First, let's get staff reports, and then we'll get back to you.
Yes, we have a letter from the Canton Community Association. They write, it is not often that we would take a position contrary to that of a Canton resident in close proximity to a proposed redevelopment project. But in this case, we must do so and advise the board that we support Mr. Valeri's variance application. He has shown himself to be a very conscientious developer who has made every reasonable effort to reach out to Mr. Tenney and the neighbors of the subject property and to address any concerns. And we believe that Mr. Tenney's concerns, most of which do not seem to relate to the requested variances, do not appear to be warranted under the circumstances. Does planning have a report?
Thank you. Planning Department has no comment on this application.
Thank you. Okay, Mr. Prado.
Sure. So this project involves a historic renovation of the existing building with a second floor rear addition and rooftop deck, as you stated earlier. We've come to an agreement with the next door neighbor at 528.
Yes, 528.
South Decker, and that agreement involves reducing the size of the rear addition as well as having something in agreement that will not use his party wall for the rooftop deck. And we have agreed to reduce the size of the addition by 4 feet. It was originally proposed as 12'3" by 16. We've agreed to reduce by 12'3" by 12, as well as put in writing, which we don't have at this moment since we just agreed out in the hall, well, to not use his party wall for the rooftop deck, and we have other engineering methods to put that up. And so, hopefully by the end of this week, we'll submit new plans both to this board and Mr. Tenney, as well as the signed agreement.
Okay. All right. Any questions? All right. Thank you very much for working together and sorting
Great.
things out, gentlemen.
Thank you.
Next, we're going to jump out of turn. 2015-322, 5120 Harford Road, Tamika Williams. Afternoon. All right, and Ms. Williams, we have this as an application to use as a home daycare for 8 children within the basement of a single-family attached dwelling. Is that correct?
Yes, sir.
Okay. Do we have staff report? Well, actually, first, if you both can raise your hands and be sworn, please.
1 second. Do you swear or affirm the testimony that you're about to give in this hearing will be the whole truth and nothing but the truth?
I did.
I do.
Now, if we can have staff reports.
Okay. We have a letter from the Harford Road Community Review Panel. They write, for purposes of planning and seeking compliance with the Urban Renewal Plan, the Community Review Panel for the Lauraville Urban Renewal Plan have no objection to the proposed use as a family daycare home. This use is consistent with the general zoning, office residential, and this home-based business will not disrupt the goals of the Urban Renewal Plan to preserve the residential feel of the block. And then we have planning's report.
Thank you. Planning Department reviewed this application and is supportive of a daycare center at this location. The primary concern of the department is that this is located on Harford Road, where in the morning, the inbound traffic for the morning rush hours may be an issue if there are parents attempting to drop off or pick up children during those hours. The department, of course, has on numerous other occasions recommended that the applicants consult with the city's Department of Transportation and the Parking Authority of Baltimore City concerning possibly creating a passenger loading zone in front of the property in order to have a safe drop-off and pickup area. The department therefore recommends approval of this appeal, subject to the condition that the applicant consult the Parking Authority of Baltimore City concerning a possible passenger loading zone in front of the property. Thank you.
Thank you. Okay, Ms. Williams, I guess first, you two stepped out in the hallway earlier. Were you able to have a discussion and get anything resolved?
We talked, but, I was stating that what the recommendation said, saying that I was gonna look into that as, you know, as a possible aspect of me having the kids get dropped off. She was stating that she don't see how they can authorize that, but. That's
Okay. All right. So why don't you tell us about what it is you're planning at the location, and I guess at some level you'll have to consider how parents are going to be dropping kids off. So if you want to also talk through sort of what you're thinking is on that as well.
I did think some parents could drop their kids off through the front until I realized that the traffic would be an issue. But we also have the back area where people park their cars. We drive through in and out and come out where people could come through and drop their kids off too. When I spoke to the urban review panel, I told them the same thing. They didn't really say that they had an issue with parents dropping their kids off. And my neighbors have seen the sign. The sign has been out there since September the 1st. Nobody complained about, you know, me trying to open the daycare or say that they had an issue with the kid, with me opening it up, or that the parking would be an issue. So I was thinking that maybe we could use the back. But if there is an issue, then I'll try to consult with the Parking Authority of Baltimore City to see if I can get a loading zone.
Well, I think that might be a little bit backwards. I think that the condition the planning department is seeking is that you consult with them first.
Okay.
In looking at the aerial photograph that we have, certainly there's Harford Road that's there, even though it's a busy thoroughfare. I do see that the home is located kind of towards the middle of the block.
Yes.
But that on either end, there are side streets that are there. What's the parking situation like there, and what's the traffic situation?
Well, Strathmore, that's pretty fine. What's that? Ruckert?
Ruckert.
Yeah.
Well, I don't know. I can't say if the parking's that good because basically it's on one side of the street, I think. And I know in the morning, I think a school bus goes up there to drop for kids. But Strathmore is really nothing wrong with that side.
My thought was that parents will likely just simply park on the side street.
Well,
They'll park
yeah,
where they can
can.
park, and they'll walk the kid up.
Yeah.
But
They can do that. I don't know if it'll be a problem for them, but they can do that too.
And do you have like a floor plan?
Yes,
or?
I did.
Thank you.
Did it myself, so I hope you can.
I'm sorry?
I drew it myself.
That's fine.
It's a little wrinkle. This one is my emergency escape plan, and this one is my fire escape plan.
Okay. Now, the daycare is going to be located in the basement?
Yes, sir.
Okay. You're going to have 8 children?
I can have up to 8 children.
Okay. And have you had any prior experience with operating a daycare?
No, I mean, you know, I watch kids all the time. I have my grandchildren, my nieces, my nephew. They mostly over there during the summer.
Okay. And what ages do you think that you're going to have?
I would like to have somewhere between 2 to maybe like 8 or 10, no infants.
All right. And what kind of hours were you looking at?
From like somewhere from like 6 in the morning to 6 in the evening.
Okay. And since you're also, we're looking at having some older children, I guess, and by older I mean school-age children, I guess you're looking at having some sort of aftercare kind of operation?
Yeah, I will be having kids for after school, yes.
Can we keep these or do you need these back?
Oh,
If need be.
You can have them back.
Yeah,
I
was
think
gonna say.
I don't have it.
If you, I was
Make
gonna
a
say,
copy
if you
of
need
them?
them, yeah, I was gonna say that if you need them back, if you can just send us a copy just so that we have something in the file, unless we already have it.
Not yet, no.
Okay, yeah, so if you can make a
Well, we
copy
can
of
keep
it.
them.
You sure?
Yeah,
If you need a copy, let us know, we'll make sure you get it.
Okay.
Yeah, because
Okay.
what I was gonna say, what we can just do the same thing in reverse. We can make a copy of it back at the office, then send it to you.
Okay, that's fine.
All right,
Thank you.
sure. Okay, was that all?
That's all for me, unless you have any more questions.
We might, at least maybe not right now, but, ma'am,
Well, you know, my only concern.
first your name for the record?
State my name?
Yes, please.
Robin Smith.
Okay.
So my only concern is I catch the bus there every morning. A few doors from her where the daycare center is going to be. And it is a hellhound when people stop there and buses are trying to get around it and traffic's trying to get around. People are in a hurry, they're trying to get to work. It's frightening. I'm not going to be able to stand there and catch the bus. I'm going to have to walk down to the next stop if, you know, if parents do stop there to drop kids off. I just don't know how, you know, because they
And by
clear.
stop, you mean illegally double park?
Illegally double park. Like, between 7 and 9, no cars can park on that section of Hartford Road,
Yeah, it's-
all the way down.
Okay.
Because they opened it up for the bus
They
lanes.
can't,
The
they're
number
not
nine
double
double parking, but they
parking,
just
it's
can't
just
park. They're not supposed to park there
That's
between
supposed
them
to no
hours.
parking, yeah.
Okay.
So that's my only concern. It's not that she has a daycare center or that there are kids in the alley, but there just really is no safe place in front of her house for them to drop kids off. And if they want to park on Strathmore, that's great. That would be the safest place, safest thing for them to do.
Okay. And Ms. Williams, would you have any objection to either having your parents agree to park there or somehow
No.
encouraging them to park
No,
there?
I have no problem with that. I mean, it's dangerous, so it's.
I mean,
we
my
can-
thought
it
would
is
be
dangerous
that
in the morning. We don't
if-
even park there, so I wouldn't have anyone else do it.
I mean, my thinking is this, that if there's no parking that's allowed there, and Hartford Road is basically a 3-lane
Two-lane.
commercial, or 2-lane commercial highway there, someone's not going to stop their car there with another line of traffic that's gonna be going by.
Oh, they do. They do.
Well-
And I've witnessed it, and
They may, but things a little bit different when you're talking about having to get kids out of the car and that kind of stuff. And I think that simply the safer way, just thinking of a parent who has a child in daycare myself, that it would just simply be much easier to just simply park on the side street and then you just walk. You don't have to worry about all that.
And I will even meet
Getting your
them,
door taken off.
to pick their children up when they walking down, so it wouldn't be problem if they don't wanna walk all the way down, you know.
yeah, because the alley's really not an option because it's a very narrow alley.
Yeah, it's only 12 feet, so
Right.
I
Yeah.
don't think that that's really
And
feasible.
people park back there that live back there, and it's a dead end, and people leave for work in the morning. So if
Yeah.
there's cars obstructing the alley, then people can't get to work. So the only option is Strathmore and Rupert. You know, the beauty shop's on the corner there, so there's very seldom ever any parking. There's very seldom any parking in that neighborhood anyway. One-way street, a lot of apartment houses, people that have multiple vehicles. I live on Rupert, and I can never park in front of my house because of the beauty shop. And because the people live on Hartford Road that don't want to get up at 7 and move their car, park on Rupert Avenue. So that's my only concern, really, is the safety of the mothers and people waiting for the bus there.
Okay. All right. Ma'am?
So would it be a problem, because after 9 o'clock, you can park there.
Yeah.
And usually after 9 o'clock, it's a lot of space to park. So would it be a problem if parents picked up after 9 o'clock, say like 5 o'clock? if they park on the street, would that be a problem?
If it's
I mean, 'cause-
legal for them to be there.
Yeah, it's legal. I mean, you can park there, after 9 o'clock, you can park on the side of the street.
So when is, it's only from 7 to 9?
Well, I say 6 to 6, so some people might want to come, they might have to work at 7.
No, I mean, the no parking.
Oh, yes, it's from 7 in the morning to
7
9
to
in the
9,
morning.
yeah.
Just
Okay.
them
In
2
the
hours.
morning.
All right. Okay. All right. Any other questions?
No.
All right. Thank you both.
Thank you. So do we just go leave or?
You can, yeah, if you want to stick around until the end, we've got a 5 o'clock docket. But if you want to call in the morning, you can
Okay.
find out, and you can go about your day, too.
Okay.
All right,
I'm sorry.
it's no problem. All right. There we go. 2015-306, 1622 and 1624 through 34 East Lombard Street, and 9 through 21 South Bethel Street. AB Associates, care of Nate Prettle.
Oh, from Chap. Do you want to read that? No.
All right. Mr. Berry, afternoon, sir.
Good afternoon, everyone.
We have this as an application to consolidate the lots 1622 East Lombard Street, 1624 through 34 East Lombard Street, and 9 through 21 South Bethel Street. Subdivide into 23 lots and construct 3 two-story and 24-story, 23 total, single-family attached dwellings with rooftop decks and front garages at the premises. Is that correct?
That's correct.
All right. If all those giving testimony can raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
We do? I do.
All right. Do we have staff reports? Planning.
Thank you. Planning Department has reviewed this application and actually has been working with the developer and architect concerning the design of this, because this property is also in the Washington Hill Historic District and therefore is going to require a review and approval from the Commission for Historic and Architectural Preservation. The property was used as a non-conforming use. We believe that the structures that were on there have recently been demolished, and therefore it's currently actually a vacant property at this time, or unimproved property. The applicant is, as we understand it, cooperating with CHAP in attempting to save or salvage and reuse as an integral part of this project a facade along Lombard Street that has historic value as determined by CHAP. The department therefore recommends approval of this appeal, if granted, be subject to the conditions that subdivision of the property be approved by the Planning Commission, and that the design and construction of the proposed dwellings comply with the requirements of a notice to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you. All right, and Mr. Berry, is your client amenable to those conditions stated by the Planning Department?
Yes, we are.
All right. And why don't you go through what
Hey,
the client's plans are?
I'm here with the architect and engineer for the project, and they'll answer questions as necessary. But if you look at the plans that were provided you, it's a rather innovative renovation of a front portion of an historic warehouse building. As Mr. French mentioned, the back portion has been completely demolished and approved by CHAP for that demolition. We have larger plans if you need to review them, because what's going to happen behind this historic facade that'll be renovated and restored, the construction of the townhouses fronting on 2 public streets with a common rear lot area mews in the middle that will be accessed from the center arch of the historic building. Mr. French said we're working with CHAP. We actually received approval of these plans by CHAP at their July 20th meeting. And in fact, the commission was so impressed with the design that they do not require us to come back to the commission for a hearing, but actually just work with their staff on the guidelines themselves. It was a rather intensive process with CHAP. There's a lot of back and forth about how many houses. You'll notice in some of your plans that the houses that are closer to the facade are actually going to be limited to 2 stories, so that the taller houses behind really won't be noticeable to the street. This property, because of the subdivision requirements and because of the CHAP requirements that overlay it, I think certainly meet the board's test for a unique property, given that we are fronting on 2, it's a narrow property to begin with, but we are fronting on 2 public streets. One of the streets is called Iron Alley, and that will be widened by 6 feet so that provides access for both fire department and also cars accessing the garages. Before we went to CHAP, there was some discussion about how much of the historic facade had to be removed to provide for that 6-foot widening required by the fire department, and that was the compromise that the developer and the fire department and CHAP ultimately agreed to. If the board likes, we can show you a blow-up of the renderings of the project. If you have any questions, be glad to answer them, but we'd like to think that this is a significant infill project. There are several other similar townhouse projects that have been approved in the Washington Hill area within a block of this area, either on Register Street or Lombard Street. And they've been successful, and we'd like to think this will be successful as well.
The plans that you have, are they larger versions of?
Yes, they're larger versions, but just without taking up too much time.
This is the existing.
This is, okay, you want to tell your name so that.
With Fit EDC, I'm the architect.
And Mama Safa, I'm MA Design, I'm the engineer.
Do you gentlemen have cards? It just might be easier for the.
Yeah, we can give it to them on the way out.
Well, just go ahead.
This is the existing situation where we have the warehouse in the back, and this is actually an open lot. We are based on the.
He's gonna have to come closer. I can't hear him. Sorry.
Yeah, sir. If you
Okay,
can.
get up to the mic.
Yeah, stand up at the microphone and then that way.
So based on the CHAP approval, we have already demolished the back part, and actually we are bracing the historic front. And then on the next page. This is the preliminary site improvement plan where we have created the subdivision for the 23 lot. In the middle, we have an amused garden like the other property next to this site. So we have widened the iron alley on this side by 6 feet, and we kept a 24 feet wide amused alley. And here we have the park. Yeah, this is the landscaping we are planting to fulfill the requirements. So this is the existing situation, the existing photo, and documenting what it is right now. And we are, this is a study, the different proposal schemes we went through. This is a study we have, existing building, and when we set the facade, it will be like this, and then we do the addition, it will look like this one. So this will be the facade on both sides.
The building has been abandoned for many, many years, and this obviously will represent a tremendous upgrade to the neighborhood. And we would answer any more questions. We think the board has the authority to approve it, given the uniqueness of the property, and we think would like to get your support today.
Questions?
Good.
Thank you.
Thank you very much.
Good luck. Next, 2015-311, 3721 Roland Avenue, Michael Gallagher. The councilwoman is coming back? Okay, we can go ahead and start. All right, Mr. Gallagher?
Yes, that's me right here.
Okay, we have this as an application to subdivide the existing lot into 2 lots, to retain and renovate the existing 2-story structure, and to reduce from 2 dwelling units to a single-family dwelling with a 1-car accessory garage and open off-street parking in the rear yard, and to construct a new 2-story detached single-family dwelling with 2-car accessory garage and open off-street parking in the rear of the new lot. Is that correct?
Yes, that's right.
All right.
And I have some modifications I would add to that. Mr. McKenzie acquired.
We'll get into the modifications once we begin the case. I just needed to confirm that part.
Okay.
All right. If all those giving testimony can raise their hands to be sworn, please.
If I may, Mr. Chairperson, I don't think that the existing house will be 1-car garage.
Sir, we haven't even identified you for the record. We're going to go through the plans once we deal with the case, but right now, I just need everyone to be sworn in.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
And Madam Interpreter, if you can take the, I guess, interpretive oath.
Certainly.
Do
got
you swear
one?
to interpret faithfully the hearing as it goes? I don't have the,
Yes, I promise I will, and I'll keep it confidential on top of that.
And I
Thank
get
you.
your name, by the way.
Laura, Laura. Last name is Irwin.
And Councilwoman, since you haven't been sworn yet, we just missed you.
I'm sorry.
That's okay. If you can raise your hand and be sworn,
Sure.
please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Do we have staff reports?
Yes. First, we have a letter from the resident at 3717 Roland Avenue. I am the longtime resident of the property and am the most directly affected contiguous neighbor. After thoughtful review of Mr. McKenzie's plans, I have concluded that this project would be a tremendous negative impact, injurious to the enjoyment and value of my property and my neighborhood. For 25 years, my 14 windows have afforded me light, privacy, and an unobstructed view of the green space from the existing yard next door. With the addition of this to-be-built home, all of that will be lost. All of my windows will look directly onto the wall of a new structure and the proposed double-wide parking lot in the rear. The parking lot will directly abut my fence and will most decidedly come with the negatives of constant car headlights, water runoff, and the ongoing damage to my fence. In addition, the proposed renovation of the existing home seems to confuse me. It is to be a single-family home that keeps the second-floor fire escape and stairs, which currently act as the ingress for the second-floor tenants. It would seem unnecessary for that to remain if you do not have plans to keep that property as anything but the current and problematic rental that it is. The proposed redesign of the current structure, the profit-driven addition building at 3721, and nothing to the charm and character of the neighborhood. I do not see any positives to adjusting a lot so as to squeeze in another dwelling onto what is one of the last beautiful parcels of green space in Hampton. We have a letter from another resident. I live at 3736 Roland Avenue and am opposed to the addition of another residence at 3721 Roland Avenue. The addition of another home will diminish the quality of life for those around it. Thank you for your consideration. And we have planning's report.
Thank you. Planning Department has reviewed this application. The key points, I guess, that the department was concerned about had to do with what variances might be required. The version of the plans which was presented for the Planning Department to consider provided for a new detached building to be built. It would amount to what we would refer to in modern terminology as a zero lot line house, based with zero side yard on its north side, and it would be separated from the opposite south lot line by a distance of about 8.5 feet. Therefore, there would be 2 interior side yard variances needed for approval of that plan. In addition, the lot line would be drawn 3 feet away from the side wall of the existing structure that's now 3721 Roland Avenue. The department therefore recommends disapproval of this appeal unless the applicant provides the board with justification for approval of the variances requested. Should the approval be granted, it should be subject to the condition that subdivision of the property receives approval from the Planning Commission. Thank you.
I'm sorry, can you repeat the last line of that?
Yes. Should approval be granted, it should be subject to the condition that subdivision of the property receives approval from the Planning Commission.
And Mr. Gallagher, do you know if your client is amenable to the conditions stated by the Planning Department?
Yes.
Okay. And they are willing to agree to that?
Yes.
Okay. All right. Now, you made reference to some modifications.
Do you want to talk about that? Do you want to talk about that?
There was concern prior to when.
Your name for the record, sir?
My name is Irving Gordon McKenzie.
What is it? Irving?
Irving Gordon. When meeting Mr. Henry last week, we got some of the planning and zoning objections, and one of the biggest objection was the easement that was created. I submitted to Mr. Henry this morning a letter from the attorney indicating that that easement is being solved.
Okay, and which easement would that be?
For the garages that are at the rear of the property.
Can you tell us how it was solved?
Well, it said dissolved.
Oh, dissolved. I'm sorry. I thought you said solved. I'm sorry.
Okay, as I see it, the alley behind the property is 10 feet wide.
Yes.
And are those garages still in use?
Those garages are basically storage garages that you typically see all throughout Hampton and other communities. They're not car garages. And that alley is actually a street dedicated by the city. It's called Pleasant Place. And it's currently being used by apartment buildings that's opposite the street in the rear. That was granted, and there's like 9 or 10 parking spots on that street. That is consistently being considered an alley, but it's really a street.
All right, I see that. Councilwoman?
Yeah, we just, at some point, we need to ask a question about what it means to dissolve the easement and what it means to store in what's supposed to be an accessory garage. I just wanna, I don't know when to do that.
Okay, we can get into that like a little bit later down the line. All right. Whether it's Mr. McKenzie or Mr. Gallagher, if you can walk us through what your plans are.
Yeah, I'll do that.
Right now, when I first.
Right now, when I first got this job with Mr. McKenzie, I looked at the plan, and it shows this.
But, and you can see it was already
You can see that it was already part of the subdivision, original subdivision plan,
back
when this started.
Plat,
And it's plat,
parcel number
and
one.
parcel number one, and parcel
two,
number 2 is there.
But the active numbers.
But they have the numbers
37,
17,
that,
and that is 37.
19.
19.
Not documented.
It wasn't documented.
That is because it is attached.
That's because it's attached to 3721, as you can see.
So
So that
was
parcel
intended
really
to
was
be-
intended to be,
have its own.
was to have its own house on it.
Along. They planned that in the future.
They planned
and
that in the
future's
future, and the
now.
future's now.
And Mr. McKenzie.
And Mr. McKenzie would like to build the house there now,
According to the original.
according to the original subdivision.
Well, the
And
original, if I can interrupt, the original subdivision, the plat that you provided us, there's a note at the top that says not to be used for issuance of permits.
Maybe a copy of this.
Sure. No, it's theirs, but we have a copy in our plans. So it says, just reading the legend at the bottom, 1, the plat is of benefit to a consumer only insofar as it is required by a lender or title insurance company or its agent in connection with contemplated transfer of financing or refinancing. The plat is not to be relied on for the establishment or location of fences, garages, building, or other existing or future improvements. 3, the plat does not provide for the accurate identification of property boundary lines, but such identification may not be required for the transfer of title or securing, financing, or refinancing. So I don't know that this plat, as it
In other
was
words-
prepared, was intended to reflect a subdivision, because it says it's not to be relied on for issuance of any permits. Mr. Chairman.
I think that's correct. This is more of an informational document to show the existing conditions.
Yeah, this is a location survey, that's what it is.
But the drawings attached show the proposed subdivision on drawing S2. That's also attached. That's the latest version of the requested subdivision, which would still have to go through Planning Commission approval. It's a little bit different from what Mr. French described, because there's been some adjustments to the drawing. If it's okay, I could try to give our perspective to that. And what we determined what was needed in the way of variances.
Sure.
It may help clarify some of the issues.
I would like to add another thing to that. This is done for the sewer. The sewer was set up during the development of the entire neighborhood. And they have included the stub
for.
as it was intended
the seven
for
nineteen,
3719 to be
that
part of
plan.
that plan.
That was another.
That was just
plan.
another thing that,
And another thing is that.
and
the
another
whole
thing is that the whole neighborhood has an average of 24
divided.
feet lots.
And we want to keep
And we
that
want to keep that harmony
consistent.
and that density as shown in this picture.
And
Right now, we have the lot between two buildings,
37,
37, 17, 17, and 21. So when we build 3719, we want to make sure that it fits there in a nice way. And it's not going to be part of, blocking the windows.
This is a reminder, I need to hear what the translator is saying. I'm having a little bit of trouble.
We're both voicing at the same time. Okay, thank you.
Just an interjection, that document that you're looking at is from the Sewer and Water Department. And through our discussion with them, they had already teed off of the main sewer line for the property that we're proposing. That's not used, but it's for that property. That's not the, that's what the tee off is designed. That's why we're providing.
I understood that, but thank you for clarifying. Mr. Tanner?
For purposes of applying bulk regulations, the zoning administrator's office and the board rely on the city's Department of Public Works plat maps to use as a base for our calculations. This plat for block 3554, dated April of 1932, shows 3721 Roland Avenue to be a lot, it's located block 3554, lot 10. It's a lot that is 51 feet wide by 162 feet 6 inches deep. And I think what the appellant is saying is that that lot had already been presumed that it may at some point be subdivided, and the sewer hookups are in place to accommodate that. And that's what this represents.
Right.
But that's separate from the existing tax plat. It's not two separate lots. It's currently one lot and would need to be subdivided to accommodate this request.
Yes, that's our plan.
Right. So the drawing submitted in S2 shows the existing lot and structure, including an outline of the garages in the rear. And the proposed site plan, including the subdivision request. That shows the existing structure at 3721 will be based on a lot that is 23 feet 6 inches wide and will cover the entire width of the new lot. So in order to accommodate that, the north side of the property doesn't change, so it's already an existing non-complying structure that sits right on the property line. The south side, the new proposed lot line, will also be a zero depth requirement for the side yard and requires a variance for the interior side yard setback requirement of 10 feet. That's what's required. The new structure is going to set back on its north side of the property. It's going to set back 3 feet from the property line on the north side and 8 feet 6 inches on the south side. So both of those side yard requirements would require a variance of the 10-foot interior side yard setback for detached structures. The other variance is required is for lot area for for single-family detached structures in the R7 district. 5,000 square feet of lot area is required for each dwelling. The existing lot as is 8,287 feet, 287.5 square feet. The existing structure, if the subdivision and variances are approved, will be reduced to 3,818.75 square feet. And the new lot will be 4,468.75 square feet. The board may grant a variance to reduce the applicable minimum lot area requirements by not more than 25%. The reduction in the case for the new structure is 24.625%. And for the new lot that there will be created is a reduction of 10.625%. So there's variances. There's 2 variances required for each for each lot as proposed: the side yard setback and minimum lot area. The question about the garages is a little bit of a unique situation. In 1940, the board approved a request to construct 5 individual garages in the rear. And that was Appeal 40-210. So that's how they were allowed to be created. That was prior to the 1971 code, and at that time it was permitted to do that. However, in 1971, the zoning code recognized that there were a lot of these situations with garages that have been built over the years throughout the city. So they created a section in the code that talks about nonconforming status of certain uses. And under 13601, parking structures in residence and office residence districts were considered, and it says, notwithstanding other provisions of this title in a residence or office resident district, if all or substantially all of a structure is designed for the storage or parking of privately owned automobiles, that structure may be continued for that use. And the use does not have the status of a nonconforming use. And the use may not be changed to any nonconforming use. So those garages were allowed to continue as garages, not other uses, under the 1971 ordinance. However, if it existed as a nonconforming use, like a warehouse or storage or whatever, they were allowed to continue um, for a set period of time. And after that time, they had to revert back to a garage for privately owned passenger automobiles only. So those garages that were no longer used as parking garages basically had lost their use, and they've been there without permits since 19, I think they were allowed, like, bear with me 1 second here. 3 years. So in 1974, the non-conforming uses should have been discontinued. So I don't know what the applicant's decision was to dissolve that agreement, but I think, gave him copies of this, and that may have factored into his considerations. If those garages remain, they have to be used for parking of privately owned automobiles accessory to the structure. That's really the only use that they would be allowed to have.
That is the structures?
The garage structures in the rear. So the plan, as I believe, was to remove one of the garages on the existing structures lot so they could provide a driveway to access a parking area, which would be allowed in the rear of the yard of the property. And then the garages that would take up the entire width of the new lot, they would have to be determined, reconfigured, or whatever they have to do to use it for accessory garage for parking. I think that's all I have to say. I just wanted to get our spin on it so that the board understands where, how we looked at this site.
What's that?
Related question about what Mr. Tanner just said. Is that you can use such garages to park cars, but you can't use them for any other use because that would be non-conforming, if I'm understanding what you're saying.
Yeah.
Okay, and then the related question is, what is the impact on this plan of what is being called the extinguishment of the
Easement?
easement? I don't understand, I'm sorry to say, I don't understand what that means in terms of, do you have the garages or not? Are the garages gone?
Well, I think that we'll get into that once we
okay.
have the plan presented.
Oh, okay.
But since we're at that part, and since you mentioned the dissolution of the easement, if you can explain, A, why the easement was extinguished, and B, what impact that has on the plan that you're presenting, and I guess C, what's the ultimate fate of those garages? Are they going to be retained, or are they going to be destroyed?
I'm gonna ask you to hold up for just a second, I'm sorry, I was asked to interpret until 5 o'clock. Do you see this going quite a long time? I'm beginning to be concerned about that because I have other assignments. I was asked to interpret from 4 o'clock to 5 o'clock this afternoon, so I'm just going to ask you, what is your prediction for that?
My prediction is that, yes, this is going to continue for another hour? No.
Oh, not another hour?
No.
It puts me in a little situation, but I think I can do less than an hour. Okay. Thank you. Mhm.
The reason why it was extinguished, it was after the meeting with Mr. Henry indicating that there was an objection by zoning department saying that the garages cannot be used by anyone other than the owner of the property. That's why I had made an agreement with the person who created the easement and the attorney to go ahead and dissolve the easement.
Okay.
Now, from what I'm understanding is, by Mr. Tanner's interpretation, is that because there was no permitted use other than a parking garage, which would have been for storage, that that time has expired and it reverts back to, it has to be used as a garage. Or apply for a non-conforming use, if I'm correct, Mr. Tanner, for other than a garage, which would be storage. So then we would submit for that unconforming use or non-conforming use to be used other than a garage.
So you want to keep the garages, not knock them down?
Correct.
Why? Just a question.
They have value, the financial aspect of it. I mean, this thing has taken already since March. I'm already into other projects and have financial obligations to those other projects. So now I'm at the point where I have to make a decision financially to move forward and what I can afford to do financially or what I can't afford to do financially. And at this point, removing those garages, you know, that's
Okay, because the garage part is, I guess, is kind of interesting, but I see it as being tangential. The issues we're here for are required lot size variance, a side yard variance, and an access variance.
Right.
I don't see any of that concerns the garages. So
Yeah,
it was a 20-minute waste of time.
Okay, we
We
have to talk about the side yard variance.
Yes.
I would like to talk about that because of,
You can remind Mr. Gallagher about.
okay, so the
Talking
other
over.
side yard variance that we have, the side yard of the other house, most of them are less than 10 feet of the other houses. So that would give us the variance, it's the smallest side yard is 2 feet right now, and we have 3 feet. So only 2 or 3 in the whole community have more than 10 feet, but most of the houses have much less than 10 feet. So really, that merges harmoniously with the other houses in the neighborhood on that block.
on that specific block of this residence, we diagrammed all the houses and measured the distance between the two, and only 3 or 4 of them actually complied to that, even though they were built prior to that 10 feet side requirement. So we're not asking for anything different than what's already there and in existence,
Yes.
as far as the variances go. And if I must add, when we came in front of the board to show 3 houses, there was only 1 variance. And I have a whole flow chart here for myself as far as the whole process I went through, which created more variances than was originally asked for, which was back in June, I was asked to come to the HCC, the Hampton Community Council meeting, to show the revised plan, which was different from adding 2 houses onto that lot, attaching to the existing, which was the original appeal that we applied for. When I went to the community hearing, actually only one person that I see here, which was Mr. Trescott Bruce. He was the only person there. No one else was there that was in objection to the plan. And after reviewing that with the community, other than Ms. Clark, she was also there. It was, what we did at that point, we redesigned the plan, and what we did is we only added one house, and then we attached that house to the existing house. In doing that, based on planning, that only created one variance, and we was okay with that. But because the response that we got from the community indicating that it didn't look good, we didn't like that they were attached, they didn't like the feel and look and design of it. So based on that information, we went back to the drawing board, did another set of plans that separated those houses. And when you separate those houses, the density and lot size requirements change. Because when you attach the houses, the lot size requirement is less than if it's detached. So we detached them, and that created more variances, which is basically what the community wanted and the response I got from the neighbors. So now we're in a position where we're asking for variances or approval for these variances that, you know, was basically created by the neighbors.
And if I'm understanding the dimensions and sort of what the issue is here, the lot size is 51 feet wide.
Correct.
And by doing detached dwellings, you can't subdivide the lot without creating a lot size, without needing a lot size variance. And you can't, because it's new construction, at least with regard to one of the properties, the house has to be at least 16 feet wide. And the dimensions you get when you make the house 16 feet wide, it gives you only 8.5 feet left. So you're going to need, just by virtue of complying with the heart of the code that requires a 16-foot wide house, you're going to need a side yard variance.
Correct, absolutely.
Okay, all right.
Right.
And the issue as far as access comes up because if you're going to be offering parking, it has to be offered somewhere, and the physical condition of the lot is that it's located on a street that is 10 feet wide. And there's a property across the street that has, I guess, an apartment building that has a parking lot for a number of vehicles, it looks like on the picture, that provide access into that same street. Okay, I got it. Any questions? All right, opposition.
Thank you. My name is Mary Pat Clark, Baltimore City Council, 14th District. Let me begin by saying that while we're comparing what this block is like, please understand that there are two other properties on this block that have side yards, like the one we're trying to protect and preserve today, that came with the house. And they are, and it's written in, excuse me, yeah, 3735 and 3739 Roland Avenue also have side yards in similar dimensions to the property we're talking about. So there's just a couple houses up the street.
For accuracy's sake, I think that the drawing, at least the one that I saw, with the measurements showed that there were two houses, I think at least two, maybe three houses that had 10-foot wide side yards, but that the rest of the houses on the block did not.
Well, we are talking about...
Conforming side yards, I should say. Conforming side yards.
Well, let's not rush to judgment until we have our chance to say what we would like to if we could. I'm addressing the issue of the uniqueness of this property. It's not. In this block, there are two others like it. And there are all kinds of situations in this block, but there is only a limited amount of green space left in Hamden, because at this moment in the history, in my experience, every square inch that is green has developers who want to overbuild it in
Is it
this community.
incumbent upon, if the community wants green space, and we see this a lot in not just urban context, you also see this a lot in seaside communities too, where people want views of the water and all that kind of stuff. If the community wants green space, is it incumbent upon private property owners to provide that at their cost?
Sir, the green space was there. It's been there for 135 years at this location. The grass is real green
Sure, but
on this
isn't that on
location.
someone else's, isn't that privately owned land?
Yes, and it has been all these 135 years.
Right, and
What's
so-
being proposed by a new property owner is to take what has existed 135 years and is not unique in this block, and to convert what's a side yard into a house for sale. Now, because variances require a certain group of findings by law, we are here to say, please be sure that you review those findings, because we're losing so much green space, private and public, in this community right now. And so we're trying to preserve it. Now, the board, because it's a variance, the board has to find, and you know this well, of course, that the purpose of the variance is not based exclusively on a desire to increase the value or income potential of the property. It's been there 135 years. The variance will not be injurious to the use and enjoyment of other property in the immediate vicinity. We all heard the letter from next door about the impact on the young lady's house there, which she owns and paid for. The variance will not impair an adequate supply of light and air to adjacent property or overcrowd the land. Those are among the relevant findings that this board is required by law to make. And that's why we're here, because we believe that that gives us the right to fight for not overbuilding, not overdoing it in any community, but conforming to what's there and keeping it livable for people. So that's why we're here, and that's what we're asking for. And it's, in the long run, the value of the properties increase when they're not jammed together like they get to be in this community all the time. Go look at 3400 Roland Avenue. Go look. Just go look. And that's an example of what I'm talking about. Just leave some of the breathing room that has been provided throughout the community. Yes, it's a prosperous neighborhood. Yes, it's very popular. Yes, people want to buy houses there. We have houses for sale that are older houses that people could fix up, and that would be what we would prefer, and leave some of this green space and just space that this community is known for, and which this very overdevelopment undercuts. So I'd like, if we can have a chance to testify, we'd like that. And thank you for your consideration of the conditions and findings and of our situation.
And if I can just,
Yes.
as I understand the existing condition of the property, it's, as I said, it's 51 feet wide.
Yes, sir.
And it's one lot. From
Yes.
the tax map, it shows that most of the properties in this area are much smaller than that. But the dwelling itself, the existing structure that's there is 23 feet wide. The required side yard is 10 feet.
Yes, sir.
So coming out 10 feet from that 23-foot wide house would bring you out to 33 and a half feet. So you've got roughly 20 feet of surplus space beyond the required side yard that's sitting there.
Okay.
So the suggestion was made that the property owner should just simply leave it there.
Yes.
But just wanted to point out that the requirement that exists requires a 10-foot side yard, and then there's almost 20 feet of just surplus space.
Hallelujah.
Your suggestion, the property owner would just simply have to maintain perpetually for free for the
It's
public
not for free.
benefit.
He bought the property, sir. I'm not trying to be rude, but this is an investor who openly said to us, I'm here, I have to make money here.
Sure.
And I mean, there's no sin about being an investor who has to make money. But that's what this is about. No one owes him something because he has to cut grass instead of build a new house on a lot. These laws are for the protection of neighborhoods.
That's true, but the point that I just went into, the reason why I keep bringing that point up is, and you may not be aware of this, there are a line of cases from the Supreme Court of the United States dealing with this kind of issue, where communities, out of a desire to maintain public space, as I said, it typically comes up in the area, or at least in the cases the Supreme Court has considered, came up in the area of seaside communities, and there was a desire to maintain the natural condition of the dunes and the views, and the ocean, and all that. And there were people who came in who wanted to build on it, and the community said, no, you can't, because we like having these open spaces and the dunes the way they are, and the land to be in its natural condition. And the Supreme Court declared that to be a taking of that individual's land, and said that if the community was going to take that position, they had effectively taken that portion of the person's land.
There was somebody, a private owner?
And for that, there must be compensation paid.
Well, let me respond, if I may.
That's the condition,
If
that's
I
the
may,
situation that.
Here's the
board-
situation.
If I may finish, please, ma'am.
Sure.
So that's the view that the board has to consider.
I understand.
Because it's mandatory authority that's been declared to be the law of the land of the United States Constitution. And so it's not that the board, certainly the position that I'm talking about, is unsympathetic.
I got you.
But we have to legally have to consider things from the other side of the ledger, and that there are limitations imposed by the Constitution on the things that you're talking about. And we have to just consider how this case fits in with that precedent.
And wait, excuse me, I was next, right? I need to respond.
Yes, please.
And then I'll stop.
Well, then we'll hear
This
from the
is,
opposition, because we do need to move this along.
this is a piece of property that is zoned R7 and has been in the code book since 1971. In that same book, there are the dimensions that must be achieved in order to properly build within an R7 lot, 5,000 square feet per individual single-family house. These two lots do not measure up. When you divide and try to build two houses on that lot, they do not meet the legal documented requirements of that zoning on this property. That's different from somebody going and trying to say you can't build on a piece of land that has no zoning and no restrictions, and all of a sudden one day he woke up and somebody was saying this is not buildable. Actually, sure, he should be compensated because there was no zoning, presumably. There was no warning, there was no, somebody came like EPA and took it away. But this is not a surprise. Anyone who buys this property knows exactly the restrictions, and in the zoning code knows that that any board or court must make findings about the well-being of the neighborhood and that property before it can allow any variance on what's in the book. And so that's different from what the Supremes ruled about and down by the seashore. And maybe, I got Lake Montebello, and that's the second largest body of water in Baltimore City. And maybe there's, maybe it applies there, but it's not here in this lot because we all know the rules, and so does this gentleman.
I would say that the facts of the cases, at least that I'm aware of, aren't quite as you've represented them, but
Well,
I hear your point.
I got you. Are we, can we go? Go. Yeah, you gotta go or you.
I really don't want to. I
Well,
am
if
a
you
horrible
don't-
speaker, but that's fine. I will, because, no, I will. Bruce Truscott, and like, I live at, and I also, stutter, so I'm sorry. 3713 Roland Avenue. So I just want to also say that I sent in a letter yesterday, I believe, and I found actually 15 variances. Without the parking, it is 9. I'm seeing also lot coverage, which needs to be at least like, or not greater than sorry,
It's not your fault, just.
35%. And I believe that the one house is at like 40%. So I'm not sure if that is there also. In the front lot needs to be 20 feet. It would only be 19 feet on like unit 2 that, yes, I can see. So anyway, yes, I have this also. I'm not sure if like that's in the record or not. I do think that this is going to impact neighbors because we're going to have a house now that's built on top of, you know, her house. It's built, you know, closer to that. With the current house and the house that they're planning to build, you only have like 3 feet. There's no access. It's going to be hard to get access in there. You got a 3-foot space. I can't believe that that is okay. And also, as we have pointed out, there are 2 lots on that street that are like, you know, like that size also. These properties were built in 1880, prior to, you know, these rules. So yes, they are, you know, not at the right feet spaces, right? But we have to go by the law as it is. It has to be 10 feet. And to change that, the property owner has to prove, I believe that it says that he is going to be influenced wrongly, unduly. I don't see that. The only problem I see is that he's not going to be able to build his house. He's not going to be able to get a monetary gain. So we should not change the law just to have, like monetary gain.
Thank you.
And that's all I have. Thank you.
I have a letter. My name is Maura Lawson. I live at 3720 Roland Avenue, which is directly across the street from the proposed project. I'm not going to read the whole letter. I can give it, I'll just give you for time's
Do we
sake.
have a copy of the letter?
No, but you may have, I had sent it in, it didn't get read, so I have it here.
Okay, okay, if you want, we'll make it part of the record.
So my problem is, and I just want to go back to the proposal that was for this parking situation. We are now facing something in the neighborhood with the building of a lot of new apartments over at the Rotunda and so forth, a real possible parking crisis coming up. The proposal that the builders have made, these folk have made, for the parking pad in the back of the house. We sat there, we measured it, we actually tried out what it would take to move cars around in that space. And it really, considering that they are not planning on changing the fact that the original building is actually 2 units, they're calling it an in-law suite, but it's still access from the back. So that's 2 family units in that original property, plus 1 in the new property being built. The amount of parking that will be needed for that is significant. The way that our street is now, it is a big problem for those who live there.
Is that Pleasant Place or?
No, this is on Roland Avenue. I live directly across.
May I clarify something?
Mhm.
They are not asking for an in-law unit.
They are keeping the stairs going up to the back.
They cannot do that.
Which means like not, sir.
You can't have the steps in the back then.
They
You're
can't
taking the
have 2
steps.
dwelling units in that. They're asking for a single-family dwelling.
Okay, it's classified as that now, but it has not stopped it from being
So he
2
would have
rentals.
to reduce that second-floor dwelling unit and make it part of the single-family dwelling.
Okay, so removing that stairs and everything else. That's one of our
Whatever the
concerns.
housing, that's a code issue.
You
Right.
can have stairs. I think what Mr. Tanner is talking about is the internal layout. You can't have separate kitchens and things like that.
Okay, so all of that will be removed. That's helpful. That is helpful. The other thing is that the general frontage of all of these houses along the entire street are very, very much the same for each of the units, except for the current unit that they've done some odd build-out on. Okay? The only thing that he's planning on doing is keeping the odd build-out. So that what he's doing is he's ruining the look of the street with putting the extra thing in, but keeping these odd build-outs that have been an eyesore in the neighborhood for a long time. If you remove the build-outs, you wouldn't have 3 feet between the houses.
Right, that's true.
Thank you.
Yeah, I'm Amy Anderson. I'm at 3717. I'm the neighbor that wrote the letter that the gentleman read initially. So I'm the neighbor most affected by this. I understand that, it's a possibility that you can build on this lot. I think that it's fine to make a profit. What we're saying here is that we have disagreement with that action. And bottom line, I would say that the decision should be based upon the law, and we're here because it doesn't fit within the law. So I would assume that since it does not fit within the law, that it should not and could not be done. And we're here just to give extra oomph to the fact that while you can override the law at some point, we're bringing the neighborhood personal point of view that we would just, we don't see it as a benefit, and that it is an out-of-town guy who came and bought it, he wants to make a profit, he wanted 3, now he couldn't have 3, now he wants 2. He wants to build on it, it's not a plus, and again, bottom line, it should happen if it is within the law. It appears that it's not within the law, and you have to adjust a lot of pieces of the law for something that I don't see as a great thing in the end. So that's what I want to say.
Yes, I'm Dennis Lynch. I'm a retired school teacher from Baltimore City. Taught from 1973 till 2003. Taught at Robertpool Middle School for 20 years and then went on to Western High School. I grew up in Hamden. I belong to the Merchants Association. The historic, we just formed another group called the Historic Hamden Heritage, that we are highlighting the history of Hamden, the civic, the religious buildings. I'm going to reinforce what Councilman Mary Pat Clark said. It's so wonderful to have a green space. It's great for the kids. It's great to walk down aesthetically. And then the other thing that I'm concerned about is the amount of building going on in Hamden and the traffic. We had such an issue. If you lived in that block, my wife and I went from door to door because we had to talk to people about the parking issue. And Mary Pat Clark knows that parking issue pretty well.
You know it very well.
I would really like to see that space remain green. I would also like to see the street not be so crowded with automobiles and builders that are taking beautiful pieces of Hamden, and eventually it just seems like everybody's moving to Hamden in the last few years. So I'd like you to take those things into consideration.
Give me your address. Your address.
Oh, I'm sorry, 3739 Roland Avenue.
We do support the idea of having 10,000 new people in Baltimore. We just don't think they all have to be in Hamden. On that one, yeah.
If we can have just a closing statement from the applicant.
I just find it funny that some of the respondents here have enclosed their front porch and have 5 cars, but yet they complain about parking on the street. Just find that unusual. The second issue is that they're defining green space. Their definition of green space, in my investigation and research, does not include private property. I would open the door to, if Mary Pat Clark wants to submit something to the council to purchase the property, to create a green space for the fire department,
I'll
I
rezone
would
it
definitely
tomorrow.
open myself up to those conversations and be willing to do that.
Okay.
Because I'm not opposed to that.
I'll rezone
The
it.
second thing is, going back to the attachment. After the first postponement, we came up with another solution based on planning's suggestion, is that the 3 houses were only taking up 16-foot wide lots. We needed to create a 20-foot block, which was common for that block. That's what we did, based on planning's recommendations from the first response. And then we attached the houses, which created only 1 variance, and gave us the 10-foot side yard. Again, the community did not want that. They did not want it. So I went back to the architect and created the separation to what they agreed to. The third thing is, I find it, I don't know, it kind of like angers me a little bit that every time I present something to the zoning and planning, they always tell me each property stands on its own merits, do not compare it to other properties. But yet, when I invited Ms. Mary Pat Clark out to the property to look, her response was, I cannot support this because it sets precedent for the other property owner down the street to be able to divide his property. Again, she's comparing it to another property that she opposed, and now she's opposing mine because of that, but yet through this whole process, I'm not supposed to compare what has been allowed with other properties. And I kind of like presented the merits on its own for this specific property and did not say throughout this process, will you allow that to happen on this street? You allow it to happen on that street. So I kept to this property. The fifth thing I'd like to say is that I'm a long standing of Baltimore City. My grandmother was a part of building the harbor. I've developed in Federal Hill, Locust Point. I've spent $1.5 million in Washington Village, so I'm not an outsider. I've been to Hamden many times and have enjoyed the ambiance of the houses being lit. I enjoyed that all the houses are all individual of themselves and all different and unique, and there's really nothing the same, which makes Hampden unique in itself. So I'm not trying to step outside of that character. I'm trying to stay within it and create designs that meet that block. I did not, and when you look at these drawings, I did not put these additions on. I did not create the 2 units that are in that building. The complaints that I received from Amy, the homeowner on one side, and Robert, the homeowner on the other side, is that tenants are a problem. They're drinking, they're loud, they're obnoxious, we can't enjoy our privacy. I don't know why someone is saying that by spending realistically almost $300,000 to improve this property, that it's going to create that same nuisance that they're saying that they're not that they can't enjoy their property because of it. It's kind of like an oxymoron. You know, it really just doesn't make any sense. These bump outs have been built after Amy lived in the property. She allowed them to be built. It creates an ugly look. I agree. I don't like it. I need to improve it. The person next door, when they purchased their property, they purchased the property knowing that this property existed. I can't change that. Only thing I want to do is just improve it. I'm no hungry well, let me rephrase that. I'm not a greedy developer to the point where I don't take the community's input serious, because I have. My dialogue with the zoning committee of Hampden, with the community association, that I was invited to the hearing to discuss my plans. I sat in Amy's house with her and talked to her about my plans.
Sir, you only have 1 more minute.
Okay, so I am conscious of what they're looking for, and every step of the way, that's what I try to create. So I think that because I'm not able to develop, or they don't want me to develop on this property, I think that, you know, I'm being given the short end of the stick, really, in a figurative way of saying it.
All right, thank you.
I would like to add to that. I
We're
just
out of
want to add to
time.
what he
Sir,
said.
Sir, we're out of time. Thank you all for your time.
Okay,
Thank you.
Thank you very much.
Thank you.
For accommodating their interpreter.
Next, 2015-312, 3142 Elliott Street. Summit and Fulia Grissel. All right, sir, are you Mr. Grissel?
Yes.
Okay, we have this. We have this as an application to construct a 2-story rear addition with 1-car garage and 3rd floor rear addition with rear deck onto a single-family attached corner dwelling. Is that correct?
That is correct.
Okay. If you can raise your hand and be sworn, please, sir.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, do we have staff reports?
I have none.
Planning Department has no comment on this application. Thank you.
All right, Mr. Grissel, why don't you tell us what you're proposing with this appeal?
On the back of this property, there's a 7-foot backyard, a parking pad. I'd like to expand the backside of the house 7 feet and put a garage. And while I'm putting a garage, the 2nd floor of it is going to be an additional bedroom. And on top of that, it's going to be a 3rd floor balcony.
And do you live at the house?
I don't right now. I live next block on Robinson Street, but my family is growing, and I need bigger house, so I'm planning on,
Your intention is to move there?
oh, absolutely.
Your plans include a projection into the right-of-way for your garage, and I just wanted you to be aware that that is, the board does not have the authority to approve that. It's a minor privilege process that you have to go through separate from this hearing. You're aware of that?
I'm aware of that. Actually, the zoning gentleman advised me to go and talk to them, and I did. And they told me that they do not anymore allow the bump outs for the garages.
So that's no longer part of it?
It's not going to be bumped out. It's still going to be a garage, but it's not going to.
Okay.
Well, I have to live with it. I have to buy a small car.
Okay. I'm glad you talked to him.
So am I. I was unhappy, but
Okay, and you said right now there's only a 7-foot?
yeah, there's a 7-foot parking, 7-foot wide parking pad.
What's the dimension of in your,
7 by 16.
okay.
The house is 16 foot wide on the
Okay.
outside.
So it's only 7 feet deep?
Yes, 7 feet deep.
Okay. All right, and that's where the addition is gonna go, into
Yeah,
that 7
addition is
feet?
gonna go 7 feet, but the garage is gonna be about 10 feet toward, another 3 feet towards the house.
Gotcha.
So I have to eliminate one of the existing windows.
Okay. Any questions? All right, thank you very much.
Thank you.
All right, and at this point, our 3 o'clock docket is concluded, and we'll turn to our 5 o'clock docket, which we'll go right into. All right, good afternoon or good evening, and welcome to the September 22nd, 2015 convening of the Baltimore City Board of Municipal and Zoning Appeals. This is our 5 o'clock docket. Before we get started, a few house rules. First, if you have a cell phone or pager, anything that makes any kind of audible electronic noise, anything that plays a ringtone, anything that beeps or chimes, and the like, we ask a minimum you turn those devices to a vibrate-only position, if not off. Similarly, if you need to have a conversation, we ask that you take that out the double doors to your rear. The rules, and the reason for those rules is quite simple. You'll note that there are a number of microphones which are arrayed around us up here. Those microphones are all very sensitive, not only for the purpose of amplification, but also for the purpose of recording these proceedings. And cell phones, pagers, and any other kind of electronic device making noise in the gallery or any conversation going on in the gallery disrupts that process as well as the general conduct of these proceedings. In the same vein, you'll note that there are 2 video cameras mounted on the wall up here behind us, and there are 3 video cameras mounted on the wall above all of you, well, most of you. And these proceedings are being recorded for broadcast on the city's cable access network. And conversations in the galleries, cell phones going off and the like disrupt that video recording process as well. We will be voting at the end of the day, which will be very soon. And you're certainly more than welcome to stick around and enjoy a civics lesson if you so choose. But if you would like, you can go and you have other plans for your evening. You can call into the zoning board office in the morning and find out how we ruled in your case. If you take out pen and paper, I'll read off the number for the zoning board office a couple of times. That number is 410-396-4301. Again, that's 410-396-4301. You will, however, need to wait until you receive the formal written outcome of your case that should be forthcoming in about 3 to 4 weeks before you'll be able to get your permit. We ask that you please not build in the city of Baltimore without first getting proper permits. If anyone is here in opposition to any case this evening, we ask that you please sign in on our sign-in sheet. sign-in sheet allows us not only to know generally which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices I just referred to. So if you want to receive the outcome of your case, the written outcome of your case, we need to know who you are and where to send it. Similarly, if your case gets postponed, we need to know who you are and how to find you to let you know when your case will be going forward, although I don't believe that there are any postponements this evening. The procedure when the cases are called, if you're the appellant, you'll come up to and you'll stand on our left or your right. The opposition, if any, will stand on our right or your left. Once everyone is up here, we'll get you all sworn in, and we'll start off with the appellant, who'll be given the opportunity to present their side of things, introduce any witness testimony, submit any documents, respond to any questions from the board, and generally tell us what it is that they're proposing. Once they're done, we will then turn to the opposition, if any, will be given the opportunity to then present their side of things, their witnesses, their documents, their evidence. Once they're concluded, we'll return back to the applicant, who'll be given the opportunity to respond to any points brought up by the opposition and to offer a closing statement. We won't be going back and forth, unnecessarily delaying things. We will be calling the cases in the order in which they appear on the docket after we first deal with some preliminary issues. And I guess the first of which are our consent agenda. The consent agenda consists of cases where the zoning board staff has already reviewed the files in these cases, and the board has determined that there is sufficient information in the record to approve these appeals. We'll call all the consent cases together as a group, so listen up to see if your case is called. The first person will line up here, everyone else will line up down the dais. Once you're all up here, we'll get you all sworn in. We'll address each case in turn. You'll be given the opportunity at that point to offer any information you would like to have added to the record. First case on the consent agenda is 2015-298, 122 East Montgomery Street, Ian Sokolowski. After that will be 2015-317, 4332 Dewey Avenue, Jonathan Murray. And last will be 2015-353, 1759 East Preston Street, AB Associates, care of Nate Prettle. Okay, is this everyone? All right. All those giving testimony, if you can raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes. Okay. First case on our consent agenda is 2015-298, 122 East Montgomery Street, Ian Sokolowski.
Good evening.
Evening, Mr. Sokolowski. We have this as an application to construct a two-story front addition and two-story rear addition at the location. Is that correct?
That is correct. However, in negotiation discussions with the adjacent neighbors, we have agreed to reduce the size of the rear addition.
Okay.
It will be a one-story addition. And I have some drawings marked up here. I can submit them to you.
Sure, sure, that's fine.
Several copies there. We've also revised the dimensions of that rear addition. The front addition will remain as submitted.
All right. Okay, Mr. French?
Planning Department has no comment on this application. Thank you.
And were you interested in seeing the revised plans at all?
We would like a copy for the file. Thank you. It's in an urban renewal area. Mhm.
All right. Anything more that you would like to have added to the record at this time?
No, sir.
Right. Zoning board staff, having previously reviewed your application, determined there is sufficient information to approve your appeal. We will incorporate your revised drawings into the approval that will be generated. So this is what we'll have, and we also will have this down as a one-story rear addition now?
Yes, sir.
All right. Okay. Thank you.
Thank you. Good evening.
Good evening. Next, 2015-317, 4332 Dewey Avenue, Jonathan Murray. Afternoon, sir. You have this as a application to construct a first-floor rear deck. Is that correct?
That's correct.
All right. And Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Murray, was there anything further you would like to have added to the record at this time?
No, I just have some pictures here, just shows that the area that I want to build the deck on is just a concrete pad that leads to an alley. It's not really usable space because it's on an incline. The deck will come out of that rear addition. I believe the city approved for a deck size of 14 by 8, was it? And so I'm looking to just extend that to use up that full area as opposed to having it just come out halfway in that back concrete pad.
All right. Is that it?
That is it.
Okay. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal. Thanks.
Thank you.
And last, 2015-353, 1759 East Preston Street, AB Associates, care of Nate Prettle. Afternoon, well, good evening, Mr. Prettle. We have this as application to use the first floor as nonprofit offices and use the second and third floors for 2 dwelling units. Is that correct?
That's correct.
Mr. French, anything for the planning department?
Thank you. Planning Department has reviewed this application and has no objection to the appeal. Thank you.
Thank you. And Mr. Prettle, is there anything further you would like to have added to the record at this time?
No, not at this time.
Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal.
Great, thank you.
Take care. All right, next, we're going to address the remaining case on our docket. Mr. Henry or Mr. Baumgartner, or anyone who has signed in opposition to?
We have no.
No, Mr. Chairman.
Thank you. Thank you very much. So we don't need to go into that part. We can just get right to it. So, calling 2015-302, 1636 McHenry Street, Reginald Weston. Afternoon, sir. You can step up to the microphone. I promise you won't fight, at least not too hard. All right. Mr. Weston, we have this as an application to add a variety store to the rear of an existing carry-out food shop. Is that correct?
Yes, sir.
All right. If you can raise your hands, I guess if the both of you are going to be testifying, if you can raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Do we have staff reports?
Okay. Planning Department reviewed the application. The applicant included in the application a hand-drawn floor plan for the carry-out and variety store combination. It appeared to show that the carry-out area would be occupying the first 33 feet of the building's length, starting from the front door, and the variety store would occupy the second 19 feet of the building's length. The aerial photograph of the property appears to show that the front portion of the building, pardon me, is actually narrower than the rear portion of the building, which suggested that the variety store would occupy the rear portion of the property, and the carryout is occupying the front portion of the property. What was not provided with the application was a floor plan showing the existing conditions of the property, the first floor specifically. Therefore, the department could not determine whether the variety store was being created separately from the carryout or whether it was being carved out of the floor area now being used by the carryout. If it in fact is being created separately, it would be an increase of non-conforming use, this property being zoned R8. And for that reason, the zoning code would limit the additional non-conforming use floor area to 25% of the floor area of the carryout as it now exists. Therefore, the proposal to add 304 square feet, more or less, for a variety store would be unapprovable. The department therefore recommends disapproval of the appeal because non-conforming use of the premises described in the application has not been properly authorized, which is another issue. We could not locate a record, but we don't have the same access to records as your staff. Secondly, should the board determine that the application is approvable, the department recommends the approval be subject to these conditions: that the floor area of the variety store not exceed 25% of the floor area of the carryout food shop, unless its floor area is being created out of the existing floor area of the carryout food shop, And secondly, that the applicant immediately obtains a use and occupancy permit for both uses of the property. Thank you.
Thank you. All right, Mr. Weston.
Yes, sir.
So are you currently operating the carryout food shop at the location? No, you're not. Okay. Is the carryout food shop currently in operation?
No, sir.
No. Okay. So what's there right now?
Just carry out. It was already a carry out.
Is it being operated?
It's not being operated. It's just a store, a storefront with equipment in it. It's basically everything.
So it's set up to be a carry out, but it's closed.
Yeah.
Okay. And do you know when it was last in operation?
Well, based on the paperwork that I ordered from downtown, they said some things was approved last year, but they didn't follow through. I don't know why the previous owners or leases didn't follow through with the paperwork, but some things were done to approve carry-out, but they just didn't follow through. After speaking with the gentleman here about the floor plans, I agreed that I was willing to extend the carry-out, the variety store floor plans out more than the carry-out. In other words, I'm willing to use more of the store for the variety store opposed to the carry-out, according to the floor plans, the way he explained it to me. I guess the way he explained it to me.
Yeah. I think it would have to be the other way around. That is, that the limitation is that if what is currently there is a carryout food shop as a non-conforming use, it wouldn't be able to you wouldn't be able to expand any other non-conforming use more than 25% of what's there.
Right.
So you'd have to limit the size of the variety store so that it's no bigger than 25% of the space for the carryout.
Yeah, that's the way he explained it to me. Yeah, that's the way he explained it to me.
All right, and we've got a letter here from Francis Hendricks.
I took that out of the file from 2010. When.
Well, it's written in 2014.
Oh, I'm sorry. I think they were asking for an extension or something.
Yeah.
But because of the length of time and the changing of the use, we advised them that they would have to follow.
Yeah, so they never established the carryout.
Well, there were attempts to, but
Is this,
for some reason or another, the permits were not
is this what it looks like?
Yes.
There were permits 2011 to do work in the property.
And he's got
That's exactly
certificates of occupancy to continue to use first floor premises as carryout food shop.
Yeah, the drawings that were submitted in 2010 with this application were a little clearer than what they have today. It showed the carryout space and then the space where they want the variety store as an office space. So it really wouldn't be an expansion of the non-conforming use. The entire first floor was used as a commercial space. Technically, that's, I think, one way of looking at it.
All right.
Franklin Square? We at Franklin Square?
All right, you've got the carry-out food area. This is, did you do this drawing here?
Yeah, I did. Yeah, I did the best.
So you've got the carry-out food area being 33 feet long,
Yeah, I did the measurements.
14 feet wide, and the variety store area as 19 feet long and 16 feet wide, which, yes, would be, the back would be wider than the front. That's a little bit odd.
It's the way the building is made. I don't know. It's got an arc with the way the building is made.
I see. Yes, we take a calculator here.
You guys did have this posted, right? Like the.
Yes, I did.
Okay.
14. Now, the carryout, when you did these measurements, and you took the measurements for the carryout area, what you have shown here, is that the current space of the carryout area, or is that what you're proposing?
Well, I was just drawing, making the measurements
Uh-huh.
of how it's already set up.
Okay.
And
So, like, what's in this part where you've got labeled variety store area?
that's the back part of the store, which is, it's a better picture here. That's this part of the store, the back part of the store.
Uh-huh.
Here, the front part is the entrance to the.
And I got that that was the back part, but I'm trying to figure out, like, what is in there right now? Does it look exactly
It look-
as
it
you've
look
drawn it out?
exactly like how I drawn it out.
Okay,
Yes,
all right.
it looks exactly how I drawn it.
All right. And is there this partition or wall that's
No,
there
it's not a
already?
partition, it's just yeah, it is a partition, it's just a door that goes to the back.
Okay,
It's just a door that goes to the back, and on the right-hand side, it's a bathroom.
okay, all right. All right, so that's 462 square feet in the carryout area. So if you're gonna be limited to 25% of that, that would only be 115 square feet, 115 and a half. And you've got variety store area of 19 times 16, that's gonna equal 304. So that would be larger than the 25%. Now, Mr. Tanner, were you saying that there's something where that limitation may not be applicable?
I'm looking for the drawing that was in the previous file. Did I pass that down with the photographs?
Hmm?
Did I pass that drawing down when I passed those photographs down with it?
Unless it's.
Is it in
labeled to
the
it.
2014 letter?
Yeah, I think so. I'm sorry.
That's okay. All right. Yes. They've
Sure.
got it labeled as an office in the
Right,
back.
yeah, that's what I was referring to.
Okay, and they've got the lobby area that's shown here, a kitchen area, and then this back area would be the office.
Right, I think that's where he wants the variety.
Yes, that's where it looks like.
Is this where they're proposing that patrons come in and out.
I think so, yes. I think that lines up to where the side door is in the drawing. All right. But if I'm trying to get it straight here, are you suggesting that the 25% limitation does not apply then? By virtue of this proposed office use shown in
Yeah,
the
if
drawing?
the office was for the carryout, it wasn't a separate non-conforming use, it was just part of the business.
Okay. All right. Any questions? All right. Thank you very much. Did you need those copies of the paperwork back, or can we put those in record?
We put them in record.
All right. Thank you. Have a good evening.
Maybe wait around, or do you just?
You can if you want.
Can if you want.
All right. And we're now off the record. That would seem to make some sense. wouldn't it? All right, which ones do we want to talk about?
Okay, then.
238?
Yeah.
238.
I don't see how we get there on 238.
I don't either.
Yeah, I had a question about that we don't have the authority.
The language, I mean, if we had the ability to grandfather it in, it would be written into the code, where I think it is in other instances. But it's-
There would have to be evidence that it was used that way. They can't just say, well, we think they had it.
Well, I'm saying crediting, even if you want to credit that testimony, which I think, yes, is a little bit sketchy.
No, I think
I don't
that-
think that we've got the ability to do it. So let's try that.
Yeah, you tried went back 8 years.
I don't think playing trivia would be considered live entertainment. I don't think that would be a
I
problem.
don't think so either.
So they don't need to come to us
Who's
for that.
playing?
For the trivia game.
Right, but for the people stand and all that.
Asked me that question, I said that would be Mr. Veal's decision.
Right. Exactly, it'd be an enforcement question.
An agreement on that. And then there's the cluster that is 311.
Before we talk to that one, can we do 322?
322. I'm fine with it, and, she said that she was, willing to agree to the conditions set by the planning department, which is that she, consult with, Department of Transportation about the possibility of a loading zone. Now, I think that it might not be feasible to do it there, but she also said that she was willing to have, her patrons do it on, park on the side street, and could Department of Transportation set up a drop-off zone there?
I doubt if they would for,
Front of the property, yeah. But in any event, she's,
You mentioned that you didn't think.
Yeah, and it's only 2
it would
hours.
create
It's
double
7 to
parking
9.
on Hartford Road.
Yeah.
I see it every day on Monroe, on Reisterstown Road.
sure.
They'll do it on Hartford Road
They're gonna
too.
park there, I mean,
Sure.
I know, but that's my I'm with the opposition on this one. I'm very fearful of doing double parking and unloading kids on Hartford Road at that time of day.
well, it's not double
Not
parking,
double
it's
parking.
single
It's-
parking.
Well, single
Parking during the 7 to 9 a.m. hour. when
But
you're
is that off to
park.
the side in an
It's
actual parking
curbside.
spot?
Yeah, it's-
All right.
it's-
You know,
it's up
my-
against the curb.
my concern is when I first started in zoning, the state allowed home daycare for up to 4 children. And it's steadily grown, now it's 8.
Yes.
But I look at this as the state's responsibility. They license the places and anybody in the city can get one just by asking for a permit.
Yes.
I don't know why we should treat her differently.
That was my thought.
Yeah, it's not about her. I just wanted to be clear on the parking stuff because
It's,
I just,
the
Crazy stuff.
demand for daycare is such that the state has, you know, allowed more and more. But anyway, that's enough said.
311, I didn't see it as being that complicated. I'm fine with all of the variances that they're seeking.
I'm with it too.
I'm a no on it.
The Republican?
It's a new Republican, new age.
I'm not. Speaking for the liberal side. I'm actually not convinced either, unless you, I mean, walk me through the individual variances and
Sure.
why it's okay.
Okay. All right, so they are asking for a lot size variance, which I think is created just by virtue of subdividing the property. As I said, when I was running through where the applicant was, the property currently is 51 feet wide. It's required to have only a 10-foot side yard, so there's 20 feet of property there that's not required for anything, and is free to be subdivided. Just by virtue of subdividing the land, you're going to need a variance of the lot size requirement just because it's being subdivided. And they can subdivide it because they don't need to do anything to conform, they don't need that other piece of the land to conform with the side yard requirement. Now, they need a variance of the side yard with respect to with respect to both of the properties. Now, that arises from, by virtue of the code, which requires that new construction has to be 16 feet wide. So with respect to the second lot, or the newly created lot, just by conforming with that requirement in the code, that 16-foot wide requirement there, you then have to have, you're only left with 8 feet. So at that point, you have to have a side yard variance requirement. It's something that just arises by operation of the code. So both with respect to the lot size requirement and the side yard variance, they're things which arise by necessity given the requirements of the code. And then the side yard needs to be varied for the original quote-unquote lot, because just by virtue of the fact that you've got now subdivided property.
Well, the variances, it's not buildable.
Okay, I mean, that's what's essentially creating the uniqueness.
The uniqueness, I think, just comes from when you look at you look at all the properties that are there. Yes, there are some which are larger size lots, but most of them, with very few exception, are all sort of your traditional row house or semi-detached lot size houses. They're like 20 feet wide or something, and this one is twice the size of all the others. So, and then, the hardship comes, as I said, just by following what's required under the code, you're going to need variances. And if you don't give those variances, then you're not going to have buildable lots. I understand the community's desire for open space, but communities can't have open space using someone else's land. I actually think that is in the Supreme Court case I'm thinking about. If you are going to have that, the community then has to pay for it. The fact of the matter is that side yards in this district, in this area, are only required to be 10 feet wide. So your open space is you're only entitled to 10 feet of that, but they want to keep that extra 20 for free. And that's taking the property. So. I thought.
There was statements by the opposition about the standards in the code about variance, and I didn't hear any rebuttal by the, we're speculating as to how it meets the standards?
Well, I went through that whole thing with them. I said, you know, at the end of their thing, after we went on the detour about the parking and all that kind of stuff, I went through it and said, well, you know, look, as I understand it, this is what the condition of the land is, and so, you know, you're gonna need this, you're gonna need the lot size variance just because it's being subdivided, and the owner said, yes, that's correct, and I think the architect even chimed in. And then I said, you need the side yard variance just because you got the houses have to be at least 16 feet wide, and so in order to do, you're left with only 8 feet in the one, and you, because it's semi-detached, you got this 3 feet of space that's on the other side, so that's where it all
The
comes from.
landowner did speak to that at the end, especially when he talked about the original plan,
Yeah.
and the reason that he went to this plan is because they didn't like having the row houses.
Yeah, they didn't want
be
the row
attached.
houses, yes.
So
which-
he detached them, and now they're poo-pooing that too. They just don't
If-
want that
No,
space.
they don't
built.
develop, yeah.
If, plus, he was willing to do semi-detached, which would not have required a variance, but they didn't like that idea.
Yes.
Because
So,
it didn't fit with the rest of the houses.
and the other factor is it's already 2 dwelling units. And
The existing dwelling.
he's taking one away and building another, and it's still only going to be 2 dwelling units. So there's no real density change.
All right, you talked me into it.
Okay.
I just have one question. Martin, you said, I think in your report, you said planning recommends disapproval, but if approved, then make it subject to approval of planning commission.
Yeah, that's
They
because of
still
the
need to get
subdivision.
planning commission
That
to.
is an issue all by itself.
Okay.
Because, as I understand it, they pushed to get the agency review of the proposed subdivision started before they got to this hearing today. I think they postponed, as I recall, so I think they might have started it
Well,
after the original.
they postponed because of the 3-lot situation.
Right, but anyway, but they have a plan in circulation right now, which is based upon attaching the new structure to the existing structure. And if they gain your approval for separated structures, and I've already mentioned this to Mr. McKenzie today, then they're gonna have to restart their
Yeah,
subdivision
done.
review process, which is
Jeez,
gonna
yes.
cost them another couple of months. You know.
Okay.
And he said, well,
All right.
so be it.
And-
So I don't know whether he wants your approval, so he can say to the community, it's one or the other, it doesn't matter, I've got approval both ways.
No,
I don't
you
know.
can't play that game.
We only approve what's in front of us.
But-
Not
and
sure
he's
why he
also-
doesn't want to tear those garages down.
I
he's
don't
also
either.
presented
Why the
a
hell are you
plan
keeping?
Which, yeah, cutting a lot line underneath a garage is not gonna be allowed by the planning commission.
Yeah.
And so he's gotta get an engineer or surveyor to redraw that lot line at the back there at Pleasant Place.
All right.
All right, that's all of them, right? Okay. 2015-234.
What about this last one in the 5 o'clock docket?
Oh, yes.
Oh,
This one?
the
2015-302.
Oh,
Um,
I'm fine with
I
it.
think you.
Yeah.
Oh, yeah, I'm okay.
yes,
Yeah.
yeah.
yes, I'm satisfied with it.
I'm very surprised there wasn't opposition to that.
I was
Which is
too.
why I asked if it was posted,
Yeah.
because I know that area. And,
Yes.
I think they just missed it.
Yeah. They never want variety stores.
But
Or carryouts. 2015-235, 1829 Gulf Street, was by consent. 2015-238, 3242 Foster Avenue, I'm a no.
No.
Agreed.
2015-252, 2 West 21st Street, was a no-show, and we'll dismiss that. Well, actually, hold on a second, maybe, instead of dismissing it, maybe
Well,
there was a miscommunication, whatever.
we'll find out if they join the others
Others,
in
this
there.
case, we can just withdraw it. 2015-282, 411 North Charles Street, was by consent. 2015-289, 530 South Decker Avenue. I'm a yes with requirement, I guess, on the condition that we receive the revised drawings per the agreement reached between the parties.
Yes.
Yes.
2015-299, 2633 Fate Avenue is by consent. 2015-300, 126 East Gidding Street was by consent. 2015-301, 1501 South Highland Avenue, and 1516 Bayless Street were postponed. 2015-305, 24 East Madison Street was postponed. 2015-306, 1622 and 1624 through 34 East Lombard Street, and 9 through 21 South Bethel Street was, I'm a yes with the condition required by Planning Department that they get a chap.
Yes.
Yes.
2015-308, 34, what was that?
And planning commission.
And Planning Commission. Oh, yeah. 2015-308, 3432 and 3436 through 44 Frederick Avenue, 3441 Old Frederick Road, and known as South Side of Old Frederick Road, 212 feet 4 inches west of South McCurley Street, was by consent. 2015-309, 614 South Chapel Street was by consent. 2015-311, 3721 Roland Avenue, I'm a yes.
Yes.
Yes. Yes.
Oh, yeah?
Yeah, I did.
We spoke at the
I'm
same
sorry.
time.
Okay.
I was gonna say, you better go for it,
We
you
have
can't.
to add something- we have to add the
2015.
subject to the approval of the planning commission?
Yes, with requirement, yes, that's correct. 2015-312, 3142 Elliott Street, I'm a yes.
Yes.
And that, I guess with the, well, he said that he wasn't doing the bump out, right?
Right.
Right.
I don't even know if you can get a curb cut, but that's another matter. That's just-
2015-315, 1604 East Clemens Street was by consent. 2015-316, 1308 West Lombard Street was by consent. 2015-318, 1441 Woodall Street was by consent. 2015-319, 3504 Druid Hill Avenue was by consent. 2015-322, 5120 Harford Road. I'm a yes with the condition that the applicant consult with the Department of Transportation about the possibility of a passenger loading zone, and that as represented by the applicant, that she encourage patrons to park on the side street, which is, it's not Ruckert, it's,
Maybe say
At least
direct,
in the morning hour.
direct
you know.
patrons to.
Swath, yeah, okay,
Yeah.
yeah. Direct the patrons to park
On the side street.
on the side streets.
We'll figure out which one.
2015-298, 122 East Montgomery Street was by consent. 2015-302, 1636 McHenry Street, I'm a yes.
Yes.
2015-317, 4332 Dewey Avenue was by consent. 2015-353, 1759 East Preston Street was by consent.
Quick question on the Hartford Road. It's not for us to decide, but didn't it come up before, what are the requirements for the ages to keep them separate?
Kids?
She was saying she wanted to go like through 2 through 10.
Yes.
Isn't there some standard
Um,
state would have imposed that she has to keep them separate somehow?
I doubt if they,
I don't think so. I think that
in home daycare.
the issue comes into play with the number of kids. The ages comes into play with the, as far as required staffing. And infants, you are required to keep apart. She's not keeping them.
Remember where it came from.